Let me just say, firstly, that this was a new kind of history for me. Most of my writing before now was very much history from the bottom up, the story of immigrants, sometimes engaged in political and social protest, often just seeking to make better lives for themselves. And in my research and teaching, I had never really addressed the fundamental question of who claimed authority over immigration in the United States and on what grounds. And addressing that question moved me away from social history, in which I was trained, and into legal and constitutional history for the first time. We know today, it's a truism, that the federal government controls immigration in the sense of deciding who to admit, exclude, or remove. In the century before, well, between the American Revolution and Reconstruction, the period I cover in the book, Congress played only a very limited role in regulating immigration. The states patrolled their borders and set their own rules for community membership, and a national immigration policy began to emerge only during the Civil War and Reconstruction. And as I discovered in my research, that was no coincidence. So the central claim in the book is that the existence, abolition, and legacies of slavery shaped American immigration policy as it moved from the local to the national level over the course of the 19th century. And in my presentation today, I just want to touch briefly on four aspects of this argument. First, the Constitution and immigration. Second, the impact of the Civil War and Reconstruction. Third, Chinese exclusion and the emergence of federal plenary power over immigration. And then finally, I'll touch on some of the ongoing tensions in immigration federalism today. So first point, the Constitution and immigration. Strangely, for a country that attracted so many immigrants, the Constitution says nothing about their admission, exclusion, or expulsion. The sole provision, as we know, has to do with naturalization. And Congress duly passed laws stipulating a waiting period, proof of good character, and oath of allegiance, restricting this policy to free white people. Other parts of the Constitution one might look at, the taxing and spending clause, the war powers clause, could be read and were read as giving some congressional authority over the field as well. The treaty power clause, I think, was more important. Throughout the 19th century, the executive branch pursued immigration policy through diplomacy, for example, with Britain and China. Most important was the Commerce Clause, which gave Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And under a temporary qualification to this power, Congress was prevented from prohibiting the external slave trade for 20 years, one of several measures by which the Constitution both recognized and protected slavery. So the question for me throughout much of the book is, to what extent did the commerce power apply to immigration and to other forms of mobility, including that of free Black people and the internal slave trade? Under the Constitution, each state retained sovereignty over matters on which it had not surrendered power to the national government, including mobility within and across its borders. Towns and states used what was known as their police power to regulate admissions and expulsions, along with the health, safety, morals, and welfare of their residents, in line with what they defined as the public good. And on this basis, they passed laws that quarantined sick passengers, that required ship captains to post bonds or pay taxes for foreign paupers and other passengers who might require public support. And they patrolled the movement of free and enslaved Black people, including free Black sailors who visited southern ports. The constitutional battle over mobility and immigration in the 19th century pitted federal commerce power against local police power. Which level of government had authority, local or national? The federal courts and the Supreme Court, as I show in the book, were unable to resolve this question before the Civil War. If the court invalidated state laws imposing taxes or bonds on foreign paupers, what about similar laws punishing free black seamen, laws in southern states expelling emancipated slaves, or laws in both the North and the South barring the entry of free black people? This brings me to my second point, the impact of the Civil War in Reconstruction. It took a civil war and the abolition of slavery to remove the constitutional and political obstacles to a national immigration policy. Yet, although the Civil War cleared a path for that policy, it would be a mistake, I argue, to think that in the absence of slavery, Congress would have regulated, let alone restricted, European immigration earlier. Following the example set by the states, Congress might have excluded vulnerable newcomers, just as it did when it passed the first General Immigration Act in 1882. But nobody before the end of the 19th century, not even the know-nothings, wanted to restrict European immigration numerically, not even Irish immigration. Some nativists called on Congress to extend the waiting period for naturalization or to regulate migration by paupers, but to no avail. Congress did not act. Admission was the norm for Europeans, and it remained so until the 1920s. So even though the abolition of slavery made the emergence of a national policy in immigration possible, it did not make that policy inevitable. So what was the historical contingency? The catalyst was the arrival in the United States of large numbers of laborers from China. Now, Chinese immigration, as we know, took a wide variety of forms, but restrictionists described all Chinese migrant workers as coolies, a degraded class of unfree workers who they insisted should be excluded from the United States. A twisted reading of the 13th Amendment produced the following syllogism. Coolies were slaves, Chinese laborers were coolies, therefore Chinese laborers must be excluded. Legislation in the 1870s and 1880s rested on this distorted anti-slavery logic with a particular emphasis on gender. So overall, Reconstruction, as I say, it had a double-edged impact on immigration. The Civil Rights Act and the 14th Amendment equipped not just citizens, but also unnaturalized immigrants, including Chinese immigrants, with federally protected rights. Under the principle of birthright citizenship, moreover, their American-born children were automatically citizens of the United States. But these egalitarian developments generated a racial backlash. And politicians in the American West, aware that the new national state that emerged after the Civil War could regulate and exclude immigrants much more effectively than any individual state, pressured Congress to act. The first two measures, as we know, were the Page Act of 1875, prohibiting the entry of Chinese prostitutes, the Chinese Exclusion Act of 1882, prohibiting the entry of Chinese laborers, the first major steps in the transition from local to federal control over immigration. These anti-Chinese measures had precedents in the antebellum South, where free Black people were required to register to demonstrate their status and their entitlement to residency, had to carry papers and produce them on demand, could be banished for certain offenses, and were often denied re-entry if they left their states. My third point concerns what we refer to as the plenary power doctrine in immigration history. When the Scott Act of 1888 unilaterally discontinued the practice of issuing return certificates to Chinese laborers already resident in the United States, one such laborer, Che Chan-ping, filed suit, claiming that he had a vested right to reside in the United States, where he had lived since 1875, and was being expelled without due process. In the so-called Chinese exclusion case of 1889, the Supreme Court ruled that his residency was a privilege, not a right, and that authority over immigrant admissions was inherent in the sovereignty of the United States as a matter of national security. The court allocated to the legislature and the executive, the so-called political branches of government, a plenary power over immigration, largely immune from judicial review. Now, this claim this claim to powers inherent in national sovereignty rested on a claim that the United States had exclusive power over the national territory. At this time, hundreds of native nations living within the borders of the United States also made claims to territorially bounded political status. And as I show in the book, it's a thread running through the book, national immigration policy rested partly on precedents in Indian law that undermined tribal sovereignty and developed in tandem with Indian policy in the post-bellum era. This doctrine of powers inherent in sovereignty was soon extended to unincorporated overseas territories as well. My final point, briefly, has to do with immigration federalism today. So the federal government has controlled immigrant admissions and expulsions since the late 19th century, but states, counties, and cities continue to regulate the lives of immigrants once they've entered the country, using their police power to do so. They play a distinctly double-edged role in this respect, depending on their location and their politics. Many local authorities today, as we know all too well, monitor, punish, and deter immigrants, support federal immigration policies, cooperate with national agencies such as ICE. Others, however, pass pro-immigrant laws, facilitating access to benefits, education, and work. Some provide sanctuary against federal surveillance, complementing grassroots efforts by faith-based organizations and other activists. The states cannot violate federal law, but neither can they be forced to implement that law. And so there is a striking, if partial, parallel here with the antebellum era, when northern states passed personal liberty laws to provide refuge for fugitive slaves and for free Black people in danger of being kidnapped into slavery. In much the same way, local jurisdictions today can provide protection to vulnerable immigrants and can refuse to act as agents of federal immigration enforcement. This raises for me the possibility that local sovereignty is not simply a matter of autonomy from the federal government. It can, in certain forms, entail an obligation to protect all people living in a given jurisdiction, regardless of their background or origin, to enhance the general welfare and public good. Now, given the long association of states' rights with racism in US history, local sovereignty is obviously a thin reed on which to base a progressive politics. Rights can be protected much more effectively if defined nationally and guaranteed by the federal government. But at times when the federal government is itself virulently anti-immigrant, as it was when I was researching this book, I think that cities, counties, and states can still play a vitally important role.